On this episode of Newt's World, the Supreme Court heard oral arguments on Wednesday in United States versus Skrmetti. The case involves 3 transgender teens, along with their parents, who are challenging Tennessee Senate Bill 1, which prohibits all medical treatments intended to allow, quote, a minor to identify with or live as a purported identity inconsistent with the minor's sex, or to treat, quote, purported discomfort or distress from a discordance between the minor's sex and asserted identity, close quote. They assert that the law violates the Equal Protection Clause of the 14th Amendment to the Constitution. In more basic terms, the transgender teens and their parents want gender-affirming care for transgender minors under the age of 18, and the state of Tennessee does not. Here to talk about the case and the oral arguments before the Supreme Court, I'm really pleased to welcome my guest, Sarah Parshall Perry. She is a senior legal fellow for the Edwin Reese III Center for Legal and Judicial Studies at the Heritage Foundation. Sarah, welcome and thank you for joining me on Newt's World.
Thank you so much for having me.
Well, I said you're at a great place, and Ed Meese is a remarkable giant who has done so many good things. It must be a great honor to be able to work with him.
It's wonderful.
Can you provide an overview of the United States versus Skrmetti and what's at stake in this case?
Sure. In fact, the parents had brought the challenge on behalf of 3 minor children that identified as transgender. And that was the originating litigation against the state of Tennessee over SB 1, which was this particular law that restricts these procedures for individuals under the age of 18. But what happened was in the Sixth Circuit on appeal, the United States intervened as it has the right constitutionally to do when an equal protection clause claim is essentially raised by the United States or one of the parties to the litigation. So they exercised their right to intervene because of a constitutional question. And that is the form of litigation that the Supreme Court took up. They did not take up the parents' rights claim itself. In fact, the underlying litigation, LW versus Skrmetti, is actually still idling right now at the Supreme Court, ostensibly pending disposition of what happens in this particular case with the United States suing the state of Tennessee. Yesterday's oral arguments, I think, indicated above all that there is very likely at least a faction of 5, if not 6, that are keen to uphold the law because the singular claim here is sex discrimination. The United States and the ACLU have argued that SB 1 discriminates on the basis of sex. What Tennessee answers is that the law itself only discriminates based on age, anyone under the age of 18, or medical purpose. In other words, the specific use to which the drugs that are being sought are put. We know, for example, some of these drugs are used for other conditions like endocrine disorders or precocious puberty, and those are not restricted. Tennessee has simply said we are restricting everyone, boy and girl, under the age of 18 from being able to access these particular medications for the use of any gender-affirming care. To my mind, this is a relatively simple constitutional question, and I think that Elizabeth Prelogar, who's the U.S. Solicitor General, took a great amount of heat yesterday in spite of some very distinct grilling from the Chief Justice, Justice Kavanaugh, Justice Barrett, and especially Justice Alito.
This kind of provision that's age-based, if I understand it correctly, is now becoming fairly common in Europe. They've experimented with this and reached the conclusion that, in fact, it's very bad public policy to allow people who are young to redefine themselves based on how they feel that year.
Yes. Yeah. In fact, the greater number of Western European nations who were originally very gung-ho, very aggressive toward medically transitioning these minor children have since backed off. Not only have Sweden, Finland, Switzerland, France to a certain extent, and England all decided that they were going to, as Justice Kavanaugh pointed out yesterday, pump the brakes on this, which I thought was significant. He used that actual terminology. But those particular studies that came out of those Western European nations, a Swedish study specifically, and the bombshell Cass report study that came out this year itself, coming from England, and that was a study of 10,000 minor children who were allowed this gender transition medicine. That played significantly into the justice's lines of questioning yesterday, especially with Kavanaugh, who said, based on what Europe's doing, we obviously know that there is not settled science in this area. That gives us what he called a yellow light, if not a strong red light, to actually prevent ourselves from intervening.
I noticed that the U.S. Court of Appeals for the Sixth Circuit actually upheld the ban, and it applied a standard known as rational basis.
Yes.
Now, what does that mean?
So that's a great question. So for your listeners, there are always tiers of scrutiny when the Supreme Court is tasked with consideration of a constitutional question. And when it is tasked with determining whether or not particular characteristics are protected under the Equal Protection Clause, it employs what's called intermediate or heightened scrutiny. Rational basis is the lowest. That means a state law is presumptively constitutional because the state has been able to simply advance a rational interest that's legitimate to its ends. Heightened scrutiny is a little bit higher of a bar. That was the one that played into the justice's rationale and lines of questioning today. For classifications based on sex, that heightened scrutiny requires a legitimate purpose, not just a rational purpose, but a legitimate purpose that is more narrowly tailored through the government regulation. So the government has to work harder to overcome that boundary of judicial review. That is what the United States and the ACLU are arguing for. They don't want presumptive constitutionality. They say that as a restriction on sex, the Supreme Court has held intermediate, heightened scrutiny to be the appropriate standard. But unfortunately here, again, this is a law that regulates based on age and use of medications for a particular purpose. No matter how many times you slice the apple, I don't think there's any way of getting around the very legitimate aims of the legislators in the state of Tennessee to protect the minors in the state boundaries that are actually subjecting themselves to these lifelong alterations.
Tell me if I've got this right or wrong. The parallel argument would be if you had a law that said you had to be a certain age to drink, that by definition, if it applied to both males and females, would not have a sexual content.
Right. That's exactly it. In fact, there was a very interesting line of questioning coming specifically from Justice Sotomayor, who said, say, for example, a young girl's growing up and she has unwanted hair, and you prevent her from getting a haircut. But a young boy is growing up and he has unwanted hair, or his hair is growing unnaturally in some way, and you give him access to a haircut, then that would be sex discrimination. And my answer to that would be, we are dealing with the procedure itself. What the United States was trying to argue was that the treatment for these particular drugs, the use of these drugs, and some of them are chemical castration agents. In fact, Lupron, we know, is given to prisoners who are sex offenders in order to chemically castrate them. So these are very, very heavy-duty medications with lifelong impact. But again, her point was, we want to treat all of the uses of these medications as the same. And I think the attorney for the state of Tennessee, Matthew Rice, very ably argued that no, there are different uses of these drugs and they have different impacts based on whether or not these individuals are boys or girls. That was the fulcrum, I think, of the legislation itself and why in the end it should be entirely constitutional.
This gets to be a big deal because there are 26 other states that have passed laws like Tennessee. So you either have the federal government and the Supreme Court intervening not just against Tennessee, but basically overturning 27 states altogether.
That's exactly it. And I do think that there are states right now who are very keen to protect their children within the state, many of whom have taken a broad brush approach like Tennessee. Some have only restricted surgeries. Some have only restricted chemical agents. Tennessee has restricted all of them. And I think it's done so based on the evolving science, based on the bombshell Cass report. This was a bipartisan bill. I think that's something that is impactful and something important for your listeners to note. On both sides of the aisle, Republicans and Democrats came forward to advance this legislation. 72% of Americans. So the broad brush of all voters in the United States want restrictions on these types of procedures for minors under the age of 18, recognizing that there is now increasing evidence that not only do these not actually solve a gender dysphoria problem, but they can, for many individuals, exacerbate undiagnosed underlying mental health conditions. Tennessee had the wind of public sentiment at its back. I believe the legislators in 26 other states have as well. And again, the people and their elected representatives are the ones who've advanced these types of bills in the interest of protecting vulnerable children.
Now, I'm not quite sure what they thought they were going to get away with, but apparently the federal government pointed also to the Supreme Court's 2020 decision in Bostock versus Clayton County. But there, the court held by 6-3 that federal employment laws that bar discrimination because of sex protect gay, lesbian, and transgender employees. I mean, it seems to me that's so explicitly focused on sex that it's profoundly different than the Tennessee law.
You know, it's interesting. Bostock did make a pretty significant appearance yesterday. And remember that Justice Gorsuch was the author of the majority opinion in Bostock in 2020, expanding sex discrimination in employment to include gender identity discrimination in employment. He did not raise a single point or ask a single question yesterday. I thought that was very compelling. That, I think, for many of us who've watched the taking off of the transgender contagion, that was in many respects the cracking open of the Pandora's box. Once sex could be included, interpreted alongside, expanded to mean gender identity under federal statutory law. That was, I think, the green light that the Biden administration needed to advance all of its gender identitarianism initiatives. We saw the first executive order coming from the White House, 13988 on January 21st of 2021, expanding, directing all of his federal agency heads to say explicitly sex included gender identity, was to be interpreted to include gender identity in all federal laws and regulations. And there are more than 100 federal laws and regulations that impact sex discrimination. So we saw implications in everything from school lunches to healthcare to housing to religious facilities, and the biggest, of course, being in education with the changing of Title IX of the Education Amendments, which is the statute that guarantees sex equality in federally funded schools. That was, I believe, in many respects for the Biden administration, their brass ring. It is the only of the federal statutes that is related solely to sex discrimination and no other category of sex discrimination. But the analysis here is different because Bostock applied solely to an employment context in a statutory vein. So this was a textualist approach. The justices were bound by what the term meant at the time of its enactment in 1964. Unfortunately, I believe Justice Gorsuch forgot that missive. I think he botched the finding, as Justice Kavanaugh wrote there. He got so caught up in the literal meaning, which for him could include gender identity or gender expression because he said they were inextricably bound up with sex. He lost the forest for the trees. And what Justice Kavanaugh wrote in his opinion in Bostock was, you are not identifying what people would have understood sex to mean when they drafted the statute in the 60s. So while that came up in Prelogger's argument, the calculus here is different, because the heightened scrutiny analysis under the Constitution's Equal Protection Clause is different than that under the statutory civil rights concept. But Prelogger tried to bring it in. She tried to crack open the door to the justice's reference to Bostock. She wanted to sort of hearken back to that. I do believe in many respects, Speaker, that it was the rent coming due moment for Justice Gorsuch yesterday, who wrote the Bostock opinion and was deadly silent during the entirety of oral arguments yesterday. But I think they can safely keep Bostock where it is, not touch Bostock. Again, it's a very young precedent. It's only 4 years old. And still find that a state has constitutional authority to be able to legislate for the welfare of the minor children within its boundaries. I don't think that's a controversial proposition.
Do you think Gorsuch will be inclined to vote with the Biden administration on this issue because of his earlier role?
You know, this is a great question. It's very clear to me the three female liberal justices will vote together as a bloc, as they have almost exclusively in the past 2 terms. Gorsuch, to my mind, is the wild card. We heard very clearly from Barrett, from Kavanaugh, from Alito, Thomas, and even the Chief Justice, who has a tendency to be sort of a middle of the road, trying to find a center route type justice. Even he put Elizabeth Prelogger, the Solicitor General, to some very, very difficult questions. The only one, obviously, we didn't hear from was Gorsuch. That, to my mind, means he is convincible by either side of the party. But at this point, it's very clear that we are, based on oral arguments yesterday, most likely to see a states' rights victory that is simultaneously going to protect minor kids.
In a memo you wrote just the other day on protecting primary parental authority from institutional challenges, you wrote that, quote, legal analysis on parental rights have been flawed. That's a pretty strong statement. Can you sort of outline and explain what you're getting at?
Sure. In fact, the Supreme Court right now has 7 pending cert petitions specifically related to iterations of the parental right. That's notable. The Supreme Court's not weighed in on the parental rights issue, and this stems from the substantive due process analysis from the 14th Amendment to the other clause, the due process clause of the 14th Amendment, which back in 1923 in Meyer versus Nebraska, the Supreme Court said it is a primary authority or primary notion that a parent can direct the care, upbringing, and education of one's minor children. They reiterated that 2 years later in Pierce versus Society of Sisters. But they are now facing a point where we've seen 24 years of silence from the Supreme Court. So some courts are now determining that 14th Amendment parental right includes the right to get experimental gender-affirming care for one's minor children. And while the Supreme Court has said, yes, there is a general right to direct your child's medical care, it has actually held that there is no constitutional right, even for adults, to get experimental or unproven care. In fact, in a case called Abigail Alliance for Better Medicine, the Supreme Court said explicitly that a patient going into hospice who wanted a very experimental last-ditch option for his treatment was not constitutionally entitled to it. So there is a little doubt in my mind to believe that if they won't grant a constitutional right for experimental care to an adult, they certainly won't grant it to a parent of a minor child.
So you see, in a sense, the court tightening up.
Yes.
On these kind of government interventions.
That is my hope. And my hope is that we can get some further clarification on the parameter of the parental right, because we are also seeing 12 million public school students right now who are in schools with explicit policies that hide gender identity information from a minor child's parent, these school confidentiality policies. Well, those parents are also claiming the 14th Amendment parental rights, saying it is our right and duty to know how our child identifies, how he is being treated at school. That, I think, is very clearly an iteration of the appropriate 14th Amendment parental right. But in many of these cases, school policies will cite FERPA, the Family Educational Rights and Privacy Act, as why they can't disclose a minor's preferred pronouns or gender identity, because it would ostensibly violate national privacy law. Well, what I think many of the courts and a lot of the school administrators have forgotten is that FERPA is a right held by the parents until the child turns 18. Once again, at some point, statutory drafters had their heads on straight, and they decided that, yes, minor children were best served by their parents being involved. So no matter how you slice this, really, these schools who were obfuscating, openly hiding gender identity information on minor kids from their parents are, I believe, ultimately going to have quite a bit of a reckoning. There is currently a case pending out of the Seventh Circuit on exactly that notion right now, and there are two more coming up from the 11th Circuit and the 6th Circuit. My hope is that if the Supreme Court doesn't take a parental rights claim this term, maybe we'll get lucky and they'll take it next term.
So when you think about all this, I mean, we're both in a struggle about whether or not children, while they're still children, should have the ability to exercise what could be lifetime decisions.
Yes.
And we're in a struggle about where do parents fit between the child and the state.
That's exactly it. And boy, isn't that an ancient question? You know, parental rights are pre-political. They are natural. They stem from that biological relationship between child and parent. They are as old as time. And there would have been a point in modern society where we never felt as though we had to iterate these as constitutional rights. But under the first challenge in 1923, the Supreme Court has used that very tricky 14th Amendment substantive due process analysis, the same one that gave us, I might add, Roe versus Wade. And now they're having to grapple with the manifestations of what this looks like in practice. If they'd never weighed in, there might have been something to say for this was an easy slam dunk. Maybe they find this right somewhere else in the Constitution. But now we have more than 100 years of Supreme Court history on parental rights, but we've got a 24-year gap. The last time they weighed in was in a visitation case about grandparents' visitation rights in Troxel v. Granville in the year 2000. It's been quite a while. I think a lot of us, especially those of us who are parents, are eager for a little clarification from the court.
Because there are times when, to use a slightly far out example, the trial we've been watching in New York, where the man who stepped in to save everybody else on the train from a person who was clearly deranged, it now turns out the guy who is saving people has to go to court and may well end up having to go to jail. A similar thing here where the state intervenes to say, we're going to do things to your child, whether you want us to or not.
That's exactly it. Part of this, I think, is what we've seen over the past decades with this sort of rebirth, this resurgence of sort of neo-Marxism, right? We were reminded with Antonio Gramsci and Karl Marx, this is the long march through the institutions. You take the institutions, you ultimately take the family, and then you take the person. I think that's why we have, in a philosophical sense, seen such an explosion in transgender identity and gender identitarianism, why we've platformed to a greater extent what are essentially grand displays of sexual fetishism. But taking the family, taking the child, ultimately guarantees cultural security for a progressive worldview. Because when you can capture young, fertile minds in the K through 6 or the K through 8 space, and now we know that these children are being indoctrinated with gender identity lessons, drag queen performances, illustrated porn in their school libraries. This is no small incursion. This is, to my mind, as the mother of 3 children, a veritable onslaught. So I think it's incumbent upon parents to really be aware of what rights they have under constitutional law, what rights they have under statutory law, and what rights they may have under their own state laws, whether that's state constitution, state code, or otherwise. That, for me, was a motivating factor behind writing this legal memo, and ultimately my hope that parents would be a little better prepared to go in boldly and say, I want to examine my son's curriculum. I want to talk to my daughter's teacher. I want to ask about the considerations of my child's special ed teacher. These are things that parents can exercise and have the right to exercise under federal law.
Just this week, you wrote an article. It's time for Washington to protect our daughters. And it's kind of an agenda setter for the Trump administration and the House and Senate Republicans. Could you kind of walk us through your thinking about how you hope President Trump and his team, both on the legislative and executive branches, will move forward?
Yes, absolutely. Well, I think the first thing that the president has to do is rescind the executive order that I mentioned earlier, that 13988, which was the executive order on combating sexual orientation and gender identity discrimination, because that was a shot across the bow, and it directed all of the federal agencies to get involved essentially in the business of gender ideology. If they had ever been sort of plain-faced, intellectually honest about interpreting federal law in the past, this gave them no excuse to do anything but buy into the president's agenda. And he has said, and I'm quite certain you've heard it before, that transgender rights are the, quote, civil rights issue of our time. I would disagree. I think that denigrates the movement, the major players in the civil rights movement in the 60s who worked so hard to actually get equality under the law. But that would be my first recommendation, to rescind that executive order and to issue a new one, doing exactly the opposite, telling all of the agency chiefs that sex is to be determined solely as it is described under federal law by the plain text, which is to say male and female. That puts the entire administration and the entire nation on notice. I think that's a good place to start. I think the next option is immediately going to the rulemaking process. Now, having served as senior counsel at the Department of Education Civil Rights Office, rulemaking is arduous. I did not think I would become expert in administrative law or the Administrative Procedure Act. You have to consider every comment, all the research, make sure it's legally sound. We did it for our previous Title IX rule that cemented due process protections for children on college campuses, that guaranteed free speech, that enhanced religious liberty rights. That was rescinded. I think the Department of Education needs to be the first office to which we send new attorneys, new investigators to roll back all of the laws that were issued, the rules that were made, that were expanded throughout every public school in the country. And I think executive guidance and rulemaking need to follow at the other agencies as well. Remember, we've seen quite a bit of damage enacted through the Department of Health and Human Services. Again, the gender ideology notion has given birth to this entire panoply, this business of gender-related care. That prevents individuals who might have moral or religious exemptions, who might not want to be involved in transing minor kids, from not being able to exercise those particular rights. A Catholic hospital who may, for example, accept patients who are federally funded or accept funding through the Affordable Care Act or through Medicaid or Medicare. These are all federal funding programs. Are they allowed now to opt out? Once again, that is, I think, incumbent upon the new agency leadership at HHS to reinvent the wheel, as it were, and have to go back to the drawing board. And then I think we need to use the government's attorneys and start investigating under civil rights law exactly where we suspect sex discrimination is taking place. And that's where I think it is women who are being forced to share bathrooms with biological boys, women who are being forced to welcome biological boys onto sports teams, women who are having housing spaces and overnight accommodations, private rooms, private spaces opened up to individuals of the opposite sex. So use the law enforcement power of the civil rights offices and the executive agencies and be able to actually put a little heat on the hangers-on that are lifetime bureaucrats who have not essentially done anything but buy in on this hard left progressive gender-related agenda.
Two sort of tough questions. One, as you know, the president and Elon Musk and Vivek Ramaswamy are all very much against the bureaucracy.
Yes, blessedly so.
To what extent do we need a new bill that radically shrinks the burden of rulemaking so that it doesn't take forever? I mean, it just strikes me that we have become muscle-bound with procedures that drag things out for 6 months or a year or 2 years.
Well, I'll mention the good news that came to us through last term at the Supreme Court in the Loper-Bright case, Loper-Bright versus Raimondo Enterprises. And this was the case that sounded the death knell on what's called Chevron deference, which is all of the leeway we give executive agencies to make rules and to be able to interpret things the way that we want. It was a horrible, judicially created doctrine. It had no place in the law. As many other horrible judicial doctrines are, it was plucked from the ether. Well, you're enforcing the rule, so you can interpret it the way that you want. And if that means redefining it, fine, we're going to look the other way. Thankfully, I think that is going to bode very, very well for the incoming administration. No longer now are we giving executive agencies the benefit of the doubt and creative leeway in creating rules, essentially out of thin air, redefining terms that they never had congressional authority to redefine. And that to me stuck out in the Loper-Bright decision, where the court wrote, if you are making a rule with vast, what they called political and economic significance, you better point to very clear congressional authority. My clarion call as a lawyer is look at the words. Textualism and originalism have to rule the day. I think coming in with this administration, first of all, you've got two individuals who I think are going to do a bang-up job with gutting the bureaucracy, shrinking the size of government. And then you've got a Supreme Court who said, and by the way, we're not going to give these federal agencies benefit of the doubt anymore. So to rewind the clock, to get back to a textualist, male, female, sex-based distinction in everything from healthcare law to education law to housing to civil rights law and beyond, I think is going to be a welcome relief for individuals in the country.
I want to thank you. I'm really impressed at your combination of academic knowledge and practical experience.
Thank you.
We need more people like you on the conservative side, and it's really been a delight to me. I want to thank you for joining me. Our listeners can learn more about United States versus Skrmetti by visiting your website at heritage.org, and we'll also have a link to the Supreme Court's oral arguments on our show page, as well as a link to your website. But Sarah, this has been terrific.
Thank you so much. It's been a pleasure, Mr. Speaker.
Thank you to my guest, Sarah Parshall Perry. You can learn more about United States versus Skrmetti on our show page at newtsworld.com. Newt's World is produced by Gingrich 360 and iHeartMedia. Our executive producer is Garnsey Sloan. Our researcher is Rachel Peterson. The artwork for the show was created by Steve Penley. Special thanks to the team at Gingrich 360. If you've been enjoying Newt's World, I hope you'll go to Apple Podcasts and both rate us with 5 stars and give us a review so others can learn what it's all about. Right now, listeners of Newt's World can sign up for my 3 free weekly columns at gingrich360.com/newsletter. I'm Newt Gingrich. This is Newt's World.